Okay. Very good evening, everyone. Welcome to today's session. Today's session shouldn't take us more than 45 minutes. It's a very simple and basic topic. But obviously, advanced concepts of this will come up in the coming sessions, which is when we'll be taking relatively longer. And I think, as requested last class, I've made a quick PowerPoint with the key terms that will be utilized in today's class for your reference. I'll be sharing this with Shriyanshu after today's class, and then I think he can send it across to all of you. I'm sorry, I'm not a guy who's heavy on. I'm not someone who's heavy on background or custom animation and clip art and stuff. So if the presentation is plain in style and design, I apologize in advance. Uh, let's get started with that. On that note, what we shall be dealing with first today is the importance and process of legal due diligence, which is coming under our first topic today, which is understanding legal due diligence, the importance, the red flags, confidentiality, and checklist review. So, understand that legal due diligence is a systematic process of investigation and verification, which is undertaken primarily in mergers and acquisitions, investment transactions, or high stake corporate restructuring to assess the legal standing and compliance status of a target entity. Now, its purpose is to provide the acquirer or investor with an informed understanding of the risks, liabilities, and legal obligations associated with the target. So, what I'm trying to say is, it just ensures that the buyer knows exactly what they are acquiring and under what legal constraints or exposures. So the importance of due diligence really cannot be overstated because it operates as the first line of defense in identifying regulatory lapses, pending litigations, contractual breaches, environmental liabilities, labor law non-compliance, or statutory dues. What it does is it helps in negotiating better transaction terms, pricing adjustments, indemnity provisions, or even deciding to call off a deal. That uh, that is what I'd like to cover in the first slide. So give you an insight into what the process of due diligence looks like. The first step, as you can see on screen, is scoping and planning. So what scoping and planning basically is where the legal counsel collaborates with the buyer or investor to understand the transaction's objective and define the depth and breadth of the diligence. So based on this, a tailored due diligence checklist is drawn up. Then comes your data collection and access, which is where the target entity uploads relevant documentation onto a secure data room, which we'll be talking about in detail, which can be either digital or physical. And this will include corporate documents, contracts, licenses, HR policies, litigation records, IPR filings, and tax assessments. The third stage, as you can see, is of document review and red flag identification, which is where legal teams analyze the uploaded documents for any legal inconsistencies, non-compliances, pending legal risks, or any issues that could materially affect the deal. So then this is followed by risk categorization and reporting, which is where findings are categorized into red flags, which are material concerns, yellow or amber flags, which are moderate concerns, and green flags, which are compliant areas or issues that can easily be rectified or remedied. So these findings are compiled in what we call a due diligence report. The last step is transaction structuring and legal mitigation, which is where, based on the report, lawyers advise on the deal structuring, the indemnity clauses, escrow arrangements, or warranties to mitigate identified risks. I think with that said, we should move on into quickly understanding what exactly is this process of red flagging. I'm sorry, before I move on, I just want to understand if everyone's able to see me navigating between slides. Like you can see the corporate red flag slide on right now.
Yes, sir.
See Muskan nodding. Thank you. So identifying red flags in corporate financial and tax records is basically where a key output of legal due diligence is put out through identification of red flags, which are basically issues that could significantly impair the target's value, hinder deal completion, or expose the acquirer to post-closing liabilities. So let's first understand how it happens for corporate records. So improper incorporation or missing registrations, right? So if there is, this is what I'd like to talk about first. So if there is a failure to produce valid incorporation documents, updated registers, or licenses under applicable laws such as Shops and Establishments Act, Factories Act, or sectoral regulators, that is a red flag. Second, if there is a non-maintenance of statutory registers. So a lot of laws, especially labor laws, mandate you to record things in record whatever mishaps or accidents or whatever aspect they intend to regulate under statutory registers. So if there are incomplete registers of members, charges, or perhaps even from the corporate governance perspective, minutes of board or and shareholder meetings, this will indicate poor corporate governance, and this is also a red flag issue. Then comes improper shareholding structures or non-compliant share issuances. So if there have been any past issuances without a requisite board, shareholder approval, or any ROC filings which may raise concerns about the legality of the capital structure, that is also another red flag. Then comes non-compliance with FDI or FEMA regulations. Now, especially in the case of foreign investment, if there has been a failure to file the forms that we discussed in the last session, the FCGPR or the FCTRS for that matter, or to comply with sectoral caps, it can result in penalties and enforcement actions by the Reserve Bank of India. That is another red flag issue that you would like to bring about. So with that being on corporate red flagging, let's move on to financial documentation, red flagging of financial documentation. This can be understood as in 3 points. But before that, please note that although financial diligence is typically led by financial experts, lawyers assess legal implications embedded in financial records. So the 3 things are: first, undisclosed or related party transactions, where unrecorded or disguised related party transactions may involve governance issues and raise red flags under Section 188 of the Companies Act of 2013. The second is improper loan or guarantee arrangements, that is, loans to directors or third parties in violation of Section 185 and 186 of the Companies Act, can definitely be called out as a red flag issue. The third is undisclosed liabilities. So if there are off-balance sheet items or contingent liabilities like bank guarantees, letters of credit, or indemnity clauses, like in contracts, of course, these may be significant. The next diligencing part that we shall be looking at is tax and regulatory red flags. So for tax and regulatory red flags, these will basically again look at 3 fundamental things. First, if there is any ongoing tax litigation, that is to say, if there are appeals pending before the Income Tax Appellate Tribunal, High Courts, or GST appellate authorities without proper disclosures. Second, if there has been a non-payment of TDS or GST or delayed filings. So if there have been regular defaults in tax reductions, filings, or e-way bill generation, it may result in penalties, interest, or scrutiny assessments. The third aspect is transfer pricing non-compliance. Now, for multinational companies, if there has been a failure to maintain transfer pricing documentation or transfer pricing audit reports, it can attract penalties. So basically, while identifying, one thing that you all should keep in mind is that while identifying red flags, it basically lies in understanding their materiality. That is to say, will the issue affect the deal's valuation, legality, or future viability? And therefore, if you're calling it a red flag, you should understand that it is a risk. It is something that is a legal risk of high magnitude, has significant legal consequence, but it does have available remedies. But there is a case of significant liability because of the penalization that will come along with it. Now, obviously, this is a very subjective assessment that you may have to make, which is why mainly you would have to see if there are like direct non-compliances which may bring about an issue to a buying entity, as a result of which you might want to you might want to take representations and warranties. Now this does not mean that you will not need representations and warranties for amber flag or for amber flagged issues or green flagged issues. This just means that the severity is a little less, because maximum for these, mostly for these instances, the penalty will definitely be in the form of a direction or an order, which will ask you to take immediate steps to correct. So that is not really attracting a risk. But at the same time, you can also make a subjective interpretation that some might come out in the public domain and harm your goodwill to a significant extent. Or they might require you to really undertake a lot of material changes, which is very cost intensive. Now, as a result of that, you might not want to, flag them as red. But if it is cost intensive or it is very good, heavy on the goodwill impact, then you might want to flag them as amber. You might want to flag them as amber issues. And now, if both of these are insignificant or both of these are relatively lesser, then you might want to flag them as the green issues. But of course, you just see a non-compliance there. Let me give you an example for an amber flag and a green flag issue. An amber flag issue can be if there is perhaps, okay, let's consider an employment agreement. Now, all of you, I'm assuming, know what a notice period means. So basically, when you are leaving, like for those of you who don't know, when you are having your employment terminated, either by yourself or by the employer for reasons other than termination for cause, which is like terminations for reasons other than misconduct by you, then there is a period like a leeway or a honeymoon period that is given to you of a specified duration, after which you will cease to be an employee of that particular organization, or a retainer or a consultant, or whatever, in whatever capacity you're engaged. Now it so happens, in an employment agreement, obviously it's applicable to an employee. Now it so happens that sometimes, to get an unfair advantage, a lot of employers, they provide for a higher notice period in case the employment agreement is the employment is being terminated by the employee, as opposed to it being terminated by the employer, or vice versa, for whatever economic benefits that they intend to gain. Or perhaps they want to look for a replacement, or they'd want to have some cost cutting done amidst the same, or they might not have a provision for notice pay unless and until there's some specific circumstance, etc. So in these cases, you understand that this creates an unfair advantage or a leverage to the employer, and the law very specifically demands for the notice period in case of termination by employee to be equal to the notice period in case of termination by employer. As a result of which, there's no unfair advantage that is gained by the employer. Now, if the employer engages in a practice such as this, where the notice period is greater on one of the ends for whatever reasons, then this becomes an amber flag issue, because while there can be pecuniary, while the employee can bring this before a court of law, the remedy that will be granted by the court is perhaps some pecuniary benefit if there is any demonstrated monetary loss that is to be paid by the employer. And otherwise, of course, if it is filed before the commencement of the notice period, the court will the court will order the employer to make sure that the notice period is equal in both circumstances. Or if the notice period is yet is 2 comments, then no matter what has been provided in the employment agreement, if it is giving a leverage to the employer, then they will ensure that it is both of them are made equal as per whatever is demonstrated to be reasonable by the succeeding party. So if that's a consideration, that will only be the consideration there, and hence it becomes an amber flag issue. Now, on the other hand, there is, like for green flag issues, you understand that now, like with the new environment guidelines coming into place, say there is an entity that is operating which takes a consent for the purposes of emitting pollutants into the air, and this, I think, comes coupled with a consent for also emitting hazardous pollutants into the air. Now, after the 2025 guidelines that came into place on January 29th, 2025. Like for air, it came into place on January 29th, 2005. For water, it came into place on January 30th, 2025. Now, if there is a transaction going on where this entity, which is basically operating with this consent is being bought by an acquirer, and the timeline for the purposes of application of renewal is coming close. And it so happens that the deadline for application basis, because the law will specify, right, you have to apply at least 10 months or at least 6 months before. It says 6 months. Like, I'm just giving you an example, so I'm just giving you hypothetical numbers. But yeah, let's just go by the law, then that just makes things better. You have to say you have to apply at least 6 months before this. Otherwise, if there is a lesser period than 6 months, penalties will apply gradually. Like if it is 6 to 4 months in advance, 25% of the application fee, then 4 to 2 months, or 4 to 3 months, 3 to 4 months. I'm sorry, I correct myself. It'll be 50%, and then gradually it goes up to 75%. And then if it's less than a month, they say it's 100%. That's how it's worded. If I'm like by way of example. So if it is going to come close to 6 months during the transaction or just after the transaction, you might want the buyer to be aware of this. But at the same time, it is not a risk because they have not yet attracted liability. So just because you want the buyer to be aware, you can't call this an amber flag issue or a red flag issue. But there is an action that has to be undertaken immediately so that the buyer does not incur any liability. And at the same time, this is not something that they would require an indemnity towards unless they are not cooperating for the purposes of applying for a renewal. Should it be clear that the expiry is going to happen while the transaction is in process or just after the transaction? Like it being at least 6 months is what I'm trying to indicate. So if that doesn't happen, then your buyer might be at a risk. That is who you're representing as a legal counsel. So then you will indicate to them that so and so is the issue, and you will indicate it as a green flag issue. So that's where the difference lies. Now, this green flag issue will become an amber flag issue if it's already been a few months and the penalty is negligible. But of course, if it's been a while since since they have applied or they've been operating without a consent for that matter, or they've not renewed it for a very long time, then that becomes a red flag issue. So this is how the flagging of the issues ideally work by way of example. If you all have any questions, feel free to ask. Okay, looks like everyone's in a good place. Let's then come to the next part of the. 1 second, I can see a question. Okay. With cybersecurity risks and data privacy issues. Okay. Good question, Palak. So for cybersecurity and data privacy issues, you will just have to see A, if there have been any past litigation. And B, for the purposes of data privacy, you might want to see if there have been employee records that have been retained in an unreasonable manner or an illegal manner, or at the same time, if there have been employee records that have been, employee information that has been procured in any manner that is not mandated under the law, or in a manner that has not been disclosed to the employees, or at the same time, if there sensitive personal data or information of the employees has been shared or has been put before a third person when in situations when it was not necessitated. So all of those is what creates create data privacy issues. So if such a thing has happened, then that's something that these will disclose to the buyer, so that any prospective liability that can accrue is something that you can get a representation or a warranty against from the buyer's end, because these are things that will definitely attract risk. At the same time, let me look at the first one. Yeah, cyber security risks as such. See, other than IT companies, you don't really have cyber security risks that are flagged in your DD report. If it's an IT company mostly, or if it's a company that is relying on cloud software or cloud management, this is when your cyber security risks will come into play. This will basically be mostly issues that are covered under the Information Technology Act. That is, if your data handling breaches any of those provisions. To be very fair, I'm sorry, these are many numbers, so it's impossible for me to really list them out for you. But so if there have been any breaches or any violation, or if the control of data has gone against any of those rules that are stipulated under the IT Act, like I mentioned, your sensitive personal data being utilized in a manner that is inimical to the interest of the person to whom such data belongs, because of it being shared with a third person in a situation when it is not necessitated. This is one of the examples. Then, of course, this will attract liability. and that's something that you might want to get a representation warranty against. But to just address your questions, another part to your question, Palak, you'll also have a lot of intellectual property based diligence that you'll have to do. So many a time intellectual properties are utilized incorrectly, or they've be like, when I say incorrectly, they've been registered in someone's name, but these people claim it under their name, or the intellectual property that has been filed for has been going on for a very long time and it's not been renewed, because the validity is only for a certain period of 30 to 60 years, depending on the kind of intellectual property that it is, as you all may be aware. So in case those renewals have not happened, that's also something that those are also things that you file, that you indicate as issues, and basis the period of the call for immediate, like if it's something that has to be renewed immediately, or if it's something that has to be renewed in some time, it becomes an amber or a green issue basis that, or if it's not been renewed and it's existing without a protection anymore, that becomes a red flag issue. At the same time, if there are any, usually your employment agreement will indicate to an employee that if there has been any intellectual property that has been acquired, that is intended to be acquired by the employee over the course of employment with this organization, then it is going to be acquired in the organization's name, uh, and not the person who really creates that whatever creates creates that entity, or creates that program, or creates a tangible or intangible object for which intellectual property protection is being sought. So if in situations like that, if there is an like a litigation that exists, because the employee has developed it outside his scope of employment, although during the scope of employment, and if they have a sufficient basis to demonstrate that it's been done out, without the utilization of the employer's resources, and there is a litigation basis, that will come as a litigation risk and not as an intellectual property risk. So it is an intellectual property litigation, so it will come under the litigation chapter as opposed to the intellectual property chapter. Many times, because the IP issues are not very significant, data privacy and IP issues come together in a DD report. But in issues where in reports where either of them or both of them are an advent, actually when both of them are an advent for that matter, they come as two separate chapters. I hope that answers your question, Palak. Okay, great. I see a thumbs up. Thank you. Um, let's come to the role of data rooms then. So the process of due diligence is heavily reliant on secure, structured, and confidential access to the target's internal records. So this is where virtual data rooms and confidentiality agreements, or that is, to simply put it, non-disclosure agreements, play a critical role. So what are data rooms, right? So right now at present, at least in law firms, we operate with virtual data rooms. So modern due diligence is conducted using virtual data rooms, which are cloud-based secure repositories where the seller uploads categorized documents for review. So these platforms provide version tracking, access logs, and permission-based controls to limit who sees what and when. So benefit of using a data room include four things. This is not something you have to write. This is just information that just needs to get into your head. First is that it's just centralized and it provides for a secure document hosting. Second, it is going to be a streamlined communication between the parties. Third is that there is an easy tracking of reviewer activity. And fourth is that it is controlled and auditable document sharing. So it's just that you must, some people, they use something as simple as a Google Drive. Sorry, excuse me. Okay, sorry for that. Uh, Very simply, a lot of people, as I was saying, they use Google Drive. A lot of people have their own cloud-based setup, and there's exclusive access given to lawyers who are working on that. If you're doing the legal due diligence bit of it, of course, there will be other financial due diligence and everything that will be done by other individuals that these people engage. And of course, the deal goes on, and exclusive access will be granted, and documents will thereafter be seen and as required, downloaded in diligence, and whatever's missing can be indicated via a requisition list, and that requisition list will highlight what exactly is missing, and then you of course get those documents uploaded and you review them, and you go back to them with a due diligence report. It's as simple as that. Let's then come to confidentiality agreements. So before granting access to the data room, The seller requires the buyer and its advisors to sign a non-disclosure agreement. So these non-disclosure agreements are legally binding, and they stipulate that confidential information must not be disclosed by to third parties. Data must be solely used for the purpose of evaluating the transaction. Confidential materials must be returned or destroyed after use, and no solicitation of employees or clients may occur during or after the review period. So some NDAs also contain what we call standstill clauses, which will prevent the buyer from making unsolicited takeover attempts for a fixed period. And breach of these non-disclosure agreements could result in contractual penalties as well as injunctive relief. So we can then say very simply that data rooms and confidentiality agreements establish the legal and technological architecture, as Taxman calls it, within which due diligence occurs securely and responsibly. So just to give you the breakdown, just to give you a rundown of the 4 points of confidentiality agreements or non-disclosure agreements again. First, confidential information must not be disclosed to third parties. Second, data must be used solely for the purpose of evaluating the transaction. Third, confidential materials must be returned or destroyed after use. Fourth, no solicitation of employees or clients may occur during or after the review period. So what exactly would be tips for you all before we get into the last part of today's class, which is your live exercise? So I think for practically, you need to understand that you need to differentiate between red flag issues and your mere compliances. Second, you need to be very, very ensure of your dates and approvals, and you need to ensure that it's all streamlined. Third, you need to look for any agreements that have been, that have not been signed or that are no longer valid. And the same will hold good for, of course, any licenses or authorizations or consents. Consents also comes under authorization, uh, which again obviously are no longer valid. Then you need to flag indemnities, warranties, or dispute clauses. And then, of course, your financial obligations and legal authorizations should always be traced. Unlike the last few classes where we went overboard, the data for today's class only stands so much. I think we'll move on to the live exercise, unless anyone has any questions.
Sir, the notes will be shared where? Like,
Yeah. I will definitely share with Shriyanshu after the session the PPT, and then I'll you can access it. But I mean, you please rely on our explanations. Those PPTs were just quick pointers with key terms. So yeah, this will be like a little bit hold good for other classes as well.
okay.
Palak has another question. What is the plan? Yeah. Shall I just take Palak's question and then I'll take your question if that's okay? What is the plan to harmonize data governance policies between two companies? Particularly, Malik, I'll take your question after I take Palak's. Data governance policies between two companies, particularly regarding a customer data handling and consent. See, to be very fair, you can't really call for a need to harmonize data governance policies, because every entity will be having their own way of going about data governance. So because see, data governance is definitely according to the law, and no entity or no company will want to violate the law. So you have a few set of standard clauses that are always there, basis the IT Act and the rules thereunder, which will be part of your data governance structure. But of course, if you are an acquiring company who's involved in a business that really requires keeping information encrypted, or keeping information categorized as sensitive and personal to the company as and when may be needed, then you will have to identify such information. You will have to define such information, and then you will have to have specific clauses that cater to exclusive protection of such information. So that's something you might want to identify as an acquiring entity, and then you will probably want to make amendments to what the data governance to your data governance policy. Yeah, but usually the acquiring company's data governance policy will succeed, so will proceed. So this is what you will like the amendments will or inclusions will be made specifically to the data governance policy of the of the acquiring company to specifically apply to this particular entity that it has acquired. Does it answer your question, Palak? Okay, I can see a thumbs up. Thanks, Palak. Yeah, Yash, I can take a question next.
So my question, I have basically two questions. First is that what if a issue that is under a red flag, like let's say, let's take a hypothetical, and it has been marked wrong, like under green flag or an amber flag. Like, so what is the remedy to that? Like, how do you address that after that?
It just means that you made a mistake as a lawyer, and
No, if it has been done deliberately, then
if it has been done deliberately, so if you don't basically you don't do a good job as a counsel then, and ultimately if it results in a situation where the representation or warranty that has to be gained towards that towards that issue that you have flagged, and likewise the action item that therein after exists for the purposes of you know uh, remedifying that non-compliance is not taken seriously by the buyer and it results in a severe penalty, they will definitely hold you accountable. I mean, you lose your client or your prospective or any prospective work from acquaintances from them, uh, as a lawyer. But at the same time, as far as your legal liability goes, you have you can have your own subjective opinion to represent your particular advice, and I don't think it should really attract any legal liability. But at the same time, of course, if you have not done your and you like you mentioned intentionally, right? So if you've not done your if they're able to demonstrate that intent and you did it so much for an unfair gain or whatever, then of course it becomes an issue of criminal breach of trust, and they can bring a case of criminal breach of trust against you under the Bharatiya Nyaya Sanhita now.
all right, sir. So my second question is, could you please explain the standstill clause again? I didn't get that.
Sorry, your standstill clause under the non-disclosure agreement.
Yes, sir. Yes.
Right. So see, standstill clauses will just basically prevent the buyer from making any unsolicited takeover attempts for a fixed period. Like what I'm trying to tell you is, if there is, if there is certain information with the buyer that usually the buyer gets during a very big transaction about the target company or the company that they're acquiring, and if they're acquiring only a fixed percentage. Now, sometimes using the information about the company that they get, they can leverage that information, put the company in a disadvantageous position by manipulating market prices or using their competitive advantage in the market and putting them on a lower pedestal and basically just make sure that they go towards a downturn and further acquire stakes in them. So to avoid that, you have a standstill clause. That standstill clause will basically ensure that for a fixed period of time, uh, you cannot act in any way that is inimical to the interests of the target company, or like you can also call it the acquired company to be acquired. And at the same time, you can also stipulate for a period, like give a fixed period of time, like maybe 2 years or 3 years, any reasonable period of time before or during which you can't basically how do I put this, you can't basically acquire further stake in that company. Is it clear?
All right, sir. Yes, sir.
No problem. Yes. Malaika, yeah, I'll be taking your question now.
The fourth point after NDA was something regarding the solicitation. I couldn't get. I mean, I didn't heard the point. So could you just
Fourth
repeat?
point. Oh, so an NDA will ensure that there is no solicitation of employees or clients that could occur during or after the review period. Like basically no poaching of employees or clients.
Right. Okay. Thank you.
Any other questions? Palak's been asking some really good questions here. Palak, are you a lawyer by any chance? I mean, are you practicing? That's what I meant to ask. Palak, are you there? Oh, crazy. Oh, this is very good. Yeah, it's good that you think this way. Good questions. I think you're more of a tech person. I can see that, but yeah, good questions. Yeah, right. Let's get into discussions, or like, okay, let's get into this exercise bit. I have a very simple way to go about it. This is just an icebreaker. This is the last part of our class. It's a rather smaller class because these are not very heavy topics. Next class will again be heavy like the last time. We'll go overboard like 1 hour 20 minutes. But yeah, to engage you all in a quick exercise, I'll give you how we'll do this is I will give you a simple instance, like this is going to be a violation. I'd want you to tell me what the violation is, how could you remedify it, and if there's any action item that you want to highlight to the buyer, I'm sorry, to the seller, what would it exactly be? So I'm sorry, before I give you that, let me just tell you how a DD report looks like by a law firm. At least in the DD work that I've done, there's a serial number. The issue is flagged. Then what exactly is the representation warranty you want to get is also flagged. Uh, and then a separate action item is flagged, or there is an action item that is flagged, and that action item will also indicate what exactly you want to. What exactly you want to get as a representation and a warranty. So my first example is there is an employment agreement that you're reviewing, and it says that you are not allowed to uh, be employed. It's an employee agreement. It is not of a key managerial person or a director. It's a normal. It's just another like any other employee, not in any management position, not any position of importance. It says that you cannot be employed by any undertaking engaged in similar business such as that of the company, that is the employer or the employing company, for a period of 2 years. Let me repeat myself. The employee shall not undertake employment in a company engaged in the same line of business as that of the employer for a period of 2 years after the termination of this agreement. So this is something you're reviewing. What is the issue in this? And B, how would you remedify this? Anyone wants to take a go? You can unmute and speak, or you can raise your hand.
So as far as the issue is concerned, I think it's the time period. The time that is given is 2 years. That's as
You're
you said.
close, but it's not the exact issue. You're close. Keep thinking, Yash. Ashu, yes.
So the time period after the employment is done over, it's unenforceable, right?
Why is it unenforceable?
Under the Indian Contracts Act.
What part of the Indian Contract Act?
Restraint
Yeah, you're right.
Trade of
But like
trade.
what section?
Restraint of trade or business. I cannot find out the
It's section
exact
27.
section.
Yeah, okay, you're right. But what exactly will be the remedy to this? Ashu's right, everyone. But yeah, what remedy is this? What will be the remedy to this?
So novation of the contract.
Novation? How? Why would you want it to be novated?
So like if we can change the time period, as that is the main issue.
Why you should never have a time period in the first place? Yash, that's the issue. It's a
All
normal
right.
employee. You should not have a post-employment non-compete.
Okay.
That is Ashu. Yeah, I'm sorry. You can continue answering. Do you think, apart from novation, if there's any other way out of it? Yes, you also think on this lines. If you don't want to novate it, how else can you novate it? You can't renew the contract as such, right? You wouldn't want to novate it. What else can you do?
So what is the B point that you said? First is what is the issue, then the next is
How can you remedify it? Which is when Yash said novation. What else?
Can there, sorry, can I go?
Yeah, go ahead.
Can there be a NDA between the two to protect the?
No. That's a non-disclosure clause. Always non-disclosure clause or non-disclosure agreement is always annexed. Let's assume that is there. The issue here is just a standard employment agreement having this contract clause. Yashu's close. Okay. Ashu, you don't have an answer to the second part?
I'm thinking about it.
It's very simple. It's a simple, very simple way out. Come on, I said Yash is close. Right. So I'll give you the answer to the first part. It's basic. Yash is right. It's a risk under Section 27 of the Indian Contract Act. It is a restrictive covenant, and this basically attracts risk for violation of Section 27 of the Indian Contract Act. While this post-employment non-compete or post termination of employment non-compete, as we would like to regard it, is valid for directors and key managerial personnel, it is not valid for employees. So therefore, you might want to remedify this in two ways. First, I also thought hard about it. Uh, First, you might want to just seek an amendment to the employment agreement, which is exactly where Yash was headed, I think. But at the same time, you will ensure that this now you'll know that this employment agreement will only apply prospectively. No, Ajay, you can't change its enforceability. You can't just merely say that the clause is no longer enforceable, right? So what you would do is you would amend the agreement to ensure that this clause no longer exists, and also you will take a representation from the target company that any prospective risk that is to arise is something that will be remedied against by the target company itself, and any any, of course, any legal action that shall arise or that shall be initiated by an employee will be attributable to the target company and not the buyer or the buying company. That is the second leg of the second leg of the representation of warranty you would want to take. I'm sorry, sir, second leg of the action item that you'd want to take. The first leg is, of course, having this clause repealed from the employment agreement for the purposes of its application to employees after the acquisition has taken place. Does that answer your question? If you all want to learn more about this, you might want to look at the Gujarat Bottling Company case, the landmark case in this regard, Section 27, Indian Contract Act, restrictive covenants, post-termination non-compete clauses. Okay, let's come to another. Let's come to this. Let's come to another question then. You look at the financial statements of a company, and you realize, Palak, same line of business is usually given a commercial interpretation. Same line of business means any business that is rendered, that any business that involves services or products, services or manufacturing of products in the same line, or in like similar to that of uh, the company that has currently engaged them, that is the employing company, and of course very similar in scale and magnitude. Now you can't compete between a local or a smaller brand of snacks and probably Haldiram's, while both of them deal with snacks. But at the same time, of course, if there are two companies that are in the same line of business, but they are of similar magnitude, let's say for example Lal and Gopal snacks, so by commercial understanding, they're in the same line of business. So that's how the understanding comes. Like, it's perfectly fine for you to use a phrase like same line of business. The second example is you go through the financial statements of a company, you understand that, and of course the corporate documentation, you understand that an annual general meeting has not been conducted for the last 3 years. So what would you do with it? How do you go about it? Come on, this is very simple. It's so straightforward. An annual general meeting has not been conducted for the last 3 years. It's blanket. Palak, you go through the financial statements of a company and the corporate documentation, and you realize that annual general meeting has not been conducted for the company for the last 3 years. Come on, guys, you can't go wrong with this one. I just explained this in the class. Let me give you a hint. Open the just think of the Companies Act, and there are two types of meeting, right? One of which is general meeting. So again, in general meetings, again there are two types: annual general meeting and extraordinary general meetings, AGM and EGM. Now they have to be conducted at a certain frequency every year, which is a statutory mandate.
Around, as far as I remember, you said 6 months they should be conducted.
Yes, no, I didn't say 6 months. Annual general meeting has to happen once in a year.
Okay.
I've indirectly given you the answer now. Okay, I'll give you the answer. This is a breach of Section 96 of the Companies Act, which mandates holding an annual general meeting every year. If it's not been done for the last 3 years, penalties will be applicable as under the Companies Act of 2013. I mean, of course, in situations where, of course, only in situations where the company is not a one-person company, because a one-person company doesn't have to have an annual general meeting. Like, I mean, one person can't basically have a meeting with himself, with themselves. I'm sorry, my bad. I correct myself. Can anyone tell me what will exactly be the remedy to this? Thanks, Palak. I'm asking you what the remedies will be.
So extension of time.
No. Why will you extend time? You're a buyer, Yash. You want to be indemnified as much as possible. 3 years they've not held an AGM and it's gone unchecked. They're really in the loop for some severe penalties. You just take a representation and a warranty where they would tell you that any legal liability that is to accrue basis violation of the basis the violations caused as a result of non-holding of a annual general meeting will be how do I put this? I mean, will be remedified or will be attributable to the target company or the company being acquired. It's just that any fine that will accrue will therefore have to be paid by the company that is being purchased. The company that is being acquired. It's as simple as that.
Got it. Thank you.
Okay. Let me give you another example. Let me ask another question. This will be the last question that I want to ask. I think everyone's fried. It's a Saturday evening. I don't want to bother you anymore. Um, okay. Now there are two companies, A and B. X, who is the brother of Y, like immediate brother, not a cousin, not a first cousin or a second cousin, immediate brother, immediate sibling. Uh, like provides a corporate loan on behalf of, on behalf of company A, where he is the director, to Y, in the name of company B, where Y is a 1% direct, Y is a singular director of company B. There's no board of directors. It's a one-person company. Y is given a loan from company A to company B as a corporate loan. Now, if does this create a risk? A, B, what risk does it create? And C, how would you remedify it? Considering a situation where company A is being acquired by company C. You want me to repeat it for you? Let me simplify it. Company A, Tanaya, sorry. Company A, company B. X is one of the part of the board of directors of company A. Y is, B is a one-person company headed by Y. X is a sibling of Y, and now X lends a corporate loan to Y. And when it's a corporate loan, of course, it's lent as a loan from company A to company B. Now C is acquiring A, and you are a legal counsel representing C. Can you flag this as an action item? Can you flag this as a violation? Come on, guys. Come on, yeah. This is a way. I just give you this example as well. Yes, obviously. It's not an issue of due diligence, but it's an issue that you will flag in your due diligence, Palak. We were speaking about diligencing of financial documents, and I give you this. This is literally the first thing I mentioned. You can look back at your notes. Let me give you a hint. X and Y are
Section 188.
siblings. Sorry?
Section 188, you said.
Yes, RPT. Thank you. Related party transaction. So,
Yes.
related party transaction, Section 188 bars corporate lending of loans between a certain, certain categories of relationships. One of which is, I mean, like a direct relation of like direct sibling relationship, because they basically try to turn down any corporate lending between blood relatives. So here, X is Y's sibling. I mentioned brother, and there's a corporate loan that is provided, a corporate lending that is done. This is a violation of Section 188 of the Companies Act. It will attract monetary penalties again. So what you will ultimately do is you will take a representation and a warranty that a penalty that is arising out of this violation is attributable to company A. If you are a legal counsel representing company C, it's as simple as that. Cool. That brings us to the end of today's class. These were three things. These are just three quick questions that I wanted to fire at you all and see how well you all are equipped. But yeah, do you all have any questions before we call it a close? Malaika, you were the one who had not attended the first class, right? And you wanted to get in touch to discuss what exactly happened. Malaika or Elita, it was one of you.
No, that was me. It's just that my exams are going on, so I couldn't
Oh,
connect with you at
great,
all.
great. I am so sorry. Please only connect when you're free. Yeah. Good luck for your exams. Anyone else, any
Thank
questions? Okay. I see that as none. Over to you, representative of legal specs.
So
Yes.
could you please
Thank
drop
you
in
so
your
much.
email and number again? I think I missed it the last time.
Yeah, sure, I'll do that.
All right. Thank you so much, sir. To the participants who are attending the meeting, I've shared a Google form on your chat box. Please fill it out before you leave. And your next session will again be held on Saturday, uh, or at 10:30 a.m. preferably, or whatever time is convened. One of us is going to let you know. Thank you everyone for joining. Have a great rest of the evening. Thank you so much, sir.
Thank you, everyone. Have a good weekend. Goodbye. No
Thank you.
worries.
Thank you, sir.
Thank you, sir.
All right, those of you who are here, please fill the form before you leave. It is going to act as your attendance for the session. Right? Once you fill out the form, you can start leaving. Thank you.